puts Amendment 7, Baroness Andrews, and I should inform the House that if Amendment 7 is agreed to, I cannot call Amendment 8. Does the noble Baroness wish to move Amendment 7 formally?
My Lords, I have spoken to this in an earlier group and anticipated that I would be pressing the Minister. I intend to test the opinion of the House on Amendment 7.
I shall now put the question. The question is that Amendment 7 be agreed to. As many are as that opinion will say content. To the contrary, not content. I'm sorry, my Lord, the question will be decided by a remote division. I instruct the clerk to start the remote division. My Lords, the remote voting period is open. Members are now invited to record their votes using the remote voting system. Members will have 10 minutes to record their votes, and I will make an announcement when the remote voting period has ended. Clear the bar.
My Lords, I can now announce the result of the remote division. The question was that Amendment 7, apologies, Division 2, Amendment 7, be agreed to. They have voted content 327, not content 223. The contents have it. My Lords, Amendment 8 has been preempted. We now come to the group beginning Amendment 9. I remind noble Lords that members other than the mover and the Minister may only speak once, and that short questions of elucidation are discouraged. Anyone wishing to press this or anything else in this group to a division should make that clear in the debate. Clause 6, Amendment 9. Baroness McIntosh of Pickering.
My Lords, I'm grateful to have this opportunity to move the amendment standing in my name and to that of Lord Fowkes, and I thank him very much for kindly supporting these amendments. So I shall be speaking to amendments 9, 13, 33, 44, 60 and 74. Amendment 9 requires the Secretary of State to publish the results of the consultation and give reasons for any decision reached. And the consultation, as referred to in clause subsection 7 of clause 6. And the reason for this is that the obligation on, looking at the history of this bill, which was drafted, we are told, at pace, with an unusually short period of consultation overall. The period of consultation was 1 month, and the responses to consultation were published on the same day. I understand that the bill itself was published and there was no consultation, no prior consultation on the actual drafts of the bill, which I understand is a most unusual procedure. Once again, I'm obliged to the Law Society of Scotland for their assistance in drafting these amendments. So the obligation on the Secretary of State to consult with the devolved administrations is welcome, but the clause as it currently stands lacks any obligation on the Secretary of State to report the outcome of the consultation with reasons for the decision. So in the interests of transparency, the government should make public the outcome of the consultation for that reason. And I hope that my noble friend, the Minister, in winding up this debate, will see fit to do that. Then the other amendments in this group all relate to the supra-affirmative resolution procedure. And Amendment 13 adapts this to Clause 8, Amendment 33 to Clause 17, Amendment 44 to Clause 20, Amendment 60 creates a new schedule on the super affirmative procedure, and Amendment 74 creates a new clause setting out the scrutiny procedure in certain urgent cases. Now, the reason for this is that the amendment seeks to introduce the super affirmative resolution procedure and the supportive schedule and new clauses I've mentioned, really to up the level of parliamentary scrutiny applicable to regulations under these clauses and new schedules, which is currently by the affirmative resolution procedure, partly for the reasons that I gave earlier, that there was woeful time given in quite unusual circumstances in which this bill has been drafted. So in changing the scope of the relevant clauses, in my view, and that of the Law Society, and I'm delighted to say Lord Fowkes as well, may have significant consequences. And it is much more beneficial that the appropriate procedure should be the super affirmative resolution procedure, which enables longer consultation and for the views of the interested parties to be taken into account. Erskine May, as I mentioned previously, at second reading, at committee stage, at paragraph 31.14, describes the super affirmative procedure as having, and I quote, been implemented in enactments where an exceptionally high degree of scrutiny is thought appropriate. For instance, for the scrutiny of certain items of delegated legislation made or proposed to be made under Henry VIII's powers. And the super affirmative procedure provides both houses with opportunities to comment on proposals for secondary legislation and to recommend amendments before orders for affirmative approval are brought forward in their final form. My Lords, in the view of the Law Society of Scotland, and I concur with this bill is of profound constitutional significance. And as the Constitution Committee report, paragraph 4, indicates, that we need, and I quote, as much scrutiny of the executive as possible, end quote. By deploying the procedure which I propose and is set out here in these amendments, this will achieve a better outcome than simply keeping with the bill in its present form and the usual affirmative procedure. I was delighted at the debate that we enjoyed in committee on the earlier manifestation of this amendment, and as summed up by Lord Thomas in his objection, that he said he could not support the precise method adopted. There may be many approaches to super affirmative resolution procedure, but the schedule which accompanies this amendment contains a detailed procedure. I'd just like to pause and quote what Lord Thomas also noted. If a minister wishes to exercise his powers under the bill, there is no requirement under the Noble Baroness's proposed schedule that scrutiny of his proposed amendment to primary legislation should in any way involve the devolved administrations. No mechanisms proposed. It is true that in paragraph 5, the Secretary of State must have regard to representations, but there is no indication from whom representations would or should come. Now, my Lords, since the Minister's power undoubtedly include the possibility that the proposals would at the very least impinge on the devolution settlement, he goes on to say, I will be more supportive of this proposal if it required as part of the super affirmative procedure that in the periods of 30, 40 or 60 days during which the proposals will be looked at in Westminster, there would be a requirement that the involved administration should at the very least be consulted, preferably that their consent to the proposal should be a necessary prerequisite. It is not enough that the minister should have regard to representations. Now, my Lords, I'm delighted to say that the schedule now provides that there is a requirement to receive representations from and to consult with the devolved administrations. We have also proposed a new clause which will deal with cases of urgency when regulations, and that is Amendment 74, we've also proposed a new clause which will deal with cases of urgency when regulations need to be presented. I'm further encouraged by the fact that I understand in private discussions I've had that the Liberal Democrats were minded to support the super affirmative procedure, but I understand that I've had less success with the official opposition. There is still time for them to change their minds. On this basis, and with these brief remarks, I beg to move.
Amendment proposed. Page 5, line 29, at end, insert the new words as printed on the marshalled list. Lord Fuchs of Cumnock.
My Lords, I'm very pleased once again to support Baroness McIntosh. And I want to just speak briefly to three of the amendments. Can I, first of all, however, say that the regulation-making powers in this bill cover very significant areas. They're not minor matters. They really are important, and that's why they do need scrutiny. And as I said earlier, I think it's the way in which the House of Lords does the work that we do the best is to scrutinise these questions, these issues rather. Can I deal first with Amendment 13? In Clause 18, the Secretary of State can, under subsection 8, make regulations to add, to vary or to remove a legitimate aim which is key in defining a relevant requirement which indirectly discriminates. A legitimate aim is defined in subsection 6 as one of the following aims. A, the protection of the life or health of animals or plants, not human animals, well, human animals and other animals and plants. And B, the protection of public safety or security. Perhaps the Minister, in his reply, could shed light on which of these the government would seek to amend in the future. I think that would be helpful. The second amendment I want to refer to is Amendment 60. And I want to speak a bit more about this, and particularly to my noble friend on the front bench. I would like to commend this idea of the super affirmative resolution. Baroness McIntosh has said she hasn't yet got the approval or the support, rather, of the official Labour official opposition front bench. But I think once we scrutinise this, once my colleagues scrutinise this in more detail, I'm sure they'll come round to supporting it, because the super affirmative resolution is described in this Amendment 60, and it provides for the laying of draft regulations and an explanatory statement by the Secretary of State to consult the devolved administrations and to have regard to their representations and the representations of other persons, and to allow for additional time for parliamentary consideration. So that is to have regard to these representations. And the importance of the Secretary of State's powers under the bill requires better scrutiny than affirmative or negative resolution procedure. We know that, and we know the fact that those are not particularly helpful ways of scrutinising legislation. Super affirmative procedure, as defined in this schedule, provides better parliamentary scrutiny, allows engagement with the devolved administrations, and enables proper consultation. And that's important to hold the government to account when such regulations are being made. So I hope my noble friend will come round to the view that at least she'll take it away and have a look and see if at a later stage the whole of the Labour members, all the Labour members, can support the super affirmative resolution. And Amendment 74, this amendment allows for the scrutiny of statutory instruments containing regulations under the bill in such a way as to allow for their urgent implementation rather than following the super affirmative procedure, because there was some concern that the super affirmative procedure would take too much time, and this deals with these matters, these issues that need to be dealt with quickly. Regulations can only be made under this provision if the Secretary of State makes a declaration contained in the right regulations that he or she is of the opinion that by reason of urgency it is necessary to meet the regulations without a draft being approved under the super-affirmative resolution procedure, and the regulations will be limited in time under subsection 4 to a period of 28 days unless instrument is approved by a resolution of each House of Parliament. So I hope that the Minister will consider these amendments carefully, and I have great pleasure in supporting the noble Baroness McIntosh in the amendments that she has moved.
I call the next speaker, Baroness Neville-Rawle.
My Lords, I rise to speak to this group of amendments in the name of my noble friend Baroness McIntosh of Pickering and the noble Lord Fuchs of Cumnock, applying a super-affirmative resolution procedure to changes to the reach of Clause 8 on indirect discrimination on services, the goods equivalents having fallen, and various other clauses. Amendment 9 requires publication of the results of consultation and reasons for decisions reached, and Amendment 74 deals with the objection to super-affirmative procedure on grounds of urgency to try and overcome the objection by my noble friend the Minister that it could cause needless delay by providing for a rapid approval in cases of urgency. My Lords, I agree with the need for consultation and explanation, but I'm not sure that this needs to be in the bill, and there would indeed be a case for an opt-out in cases of urgency, but only if this group were to find favour with our House. However, I do not believe that the case has actually been made that the super-affirmative procedure is really needed, and certainly not on the scale proposed, and in the light of the amendments already made by the government in respect of mutual recognition, in respect of goods. And I echo what the noble Lord Fuchs said about the readiness of the Minister to listen to the experts in this House and to be ready to make changes to make this legislation work. Now, I was involved in securing procedures used very selectively in the Withdrawal Act, where my noble friend, the then Minister, Lord Callaghan, was very helpful. I'm a practical person, and I have not seen any real evidence here of the need for the use of the super-affirmative procedure. We need much more specific, concrete concerns to justify my noble friend Baroness Pickering's amendment, in my view. If the movers of the amendment are just fearful, that is not enough to merit a super-affirmative procedure. So perhaps my noble friend, the Minister, could provide examples, of how the powers in these clauses will be used, and perhaps more important, why he believes the super-affirmative procedure is over the top in this case. That would sit on the record, Pepper and Hart style, and I think minimise the risk from the use of the powers in this bill.
Naseby.
My Lords, noble Lords will expect, given my 5 years in the other place in the chair, to not be surprised that I had a closer look at the super-affirmative procedure and where it's been used and where it should be used. I think the first point to make is that we all acknowledge that this is a very important bill, which is why there's an affirmative resolution within varying clauses. So we start with that. Secondly, the super-affirmative procedure involves, as noble Lords have said, an additional stage of scrutiny, where Parliament considers a proposal for a statutory instrument before the statutory instrument is formally presented, what we call laid. This procedure is used for statutory instruments that are considered to need a particularly high level of scrutiny. That's self-evident, I think. So I then checked on where they have been used. So far, these statutory instruments usually amend or repeal Acts of Parliament. Examples would include legislative reform orders, localism orders, public bodies orders, regulatory reform orders, and remedial orders. although I've only had a short time to do it, I haven't found it within primary legislation. I stand to be corrected, but I haven't found it myself. Indeed, listening to my noble friend in proposing that this procedure should be used, it seems to me it's going to be a sort of grapeshot approach, scattered throughout the bill. So that's suggesting that all these bits that are these amendments are absolutely vital to be taken specially. I just don't think it stacks up, my lords. And furthermore, because this bill is important, and because we're dealing with devolved powers who will be consulted, will be worked with, it's just going to add further delay. And that isn't in the interests of Parliament, it's not in the interests of business, commerce, or the people of the United Kingdom. So quite frankly, I certainly will not be supporting this at all. I think it's almost out of order, really.
My Lords, I now call the next speaker, Lord Beith.
My Lords, my answer to the Noble Lord Naseby is the fact that the super affirmative powers have not been very widely used in the past is really no excuse for not using them where they are an appropriate way of dealing with important statutory instruments and providing them with a higher level of scrutiny. And to the Noble Lady Baroness Rolfe, I'd say, if she doubts the need for more use of the procedure, she should recall all those occasions when we have felt that a statutory instrument should be amended, but we've had no capacity to amend it. And our dislike of a particular feature of it was not sufficient to justify blocking it or turning it down, and something, of course, that this House very, very rarely does. It addresses, although not by providing a power of amendment, but it does address the lack of amendment power, which is a characteristic of the almost the whole of the statutory instruments system. I think that the Noble Lady Baroness Mackintosh and Lord Folkes, this new coalition, this Folkes-Mackintosh group, an alternative to heckling is the constructive tabling of amendments, and we should welcome that, have done us a service in bringing this matter forward. If you worry, as I have done over many years, about the inadequacy of our procedures for dealing with statutory instruments, and especially those which try to change primary legislation, as its name suggests, super affirmative procedure is better than ordinary affirmative procedure, and better still than negative procedure, because it opens up fresh opportunities for how the matter can be dealt with. Now, because it takes more time, there should be some caution in those things for which we think it's right to use it. But I think it could be much more usefully employed than it has been in recent years. Of course, it is not a single procedure. It's a category of procedure which is usually spelt out individually in the legislation which employs it, as in this case. And the Noble Lady Baroness Mackintosh has improved and added to the process in the version of it that is now before us. The procedure allows for measured consideration. Now, sometimes measured consideration is impossible because of urgency. Things are not always as urgent as the government say they are. Usually the urgency has arisen from the fact that the government has taken too long dealing with it and has brought it to the House at a very late stage. Throughout the coronavirus epidemic, we've had all these occasions when the House has suddenly been told something has been very urgent, which the government has been dealing with for weeks and has probably even announced many days ago, but now gives the House the minimum time to address. So the government can't always claim that there's an inherent urgency in the situation, but rather that it has created urgency by delay at its stages of the process. But where measured consideration is appropriate, then the super affirmative procedures allow for it and allow the House to suggest amendments to a bill, which the government can then go back and consider. I think it has advantages, and I think it would have advantages for some of the processes in this bill. So it is not the wild suggestion that the Lord Naseby and the Baroness Neville Rolfe seem to think that it is. And I think it has many advantages which ought to be deployed in circumstances such as this.
Next speaker, Baroness Hayter of Kentish Town.
Thank you, my Lords. I mean, I do think this raises an important and much wider issue about how statutory instruments are dealt with and how much consultation goes into them. And one of the questions, as I think the Noble Lord, the Minister, often hears from all of us when we're in Moses' room, as it was, doing them, is who did you consult and can we hear the feedback of it? And I do think there's some really important lessons that we should take about that in general, because one of the issues very often is, and all of us who've dealt with them will know, that at the very last moment someone gets in touch about a statutory instrument and says, look, this really doesn't work for our industry or our sector or something, usually about the practicality of it rather than the policy, and at that stage it's too late, and that is immensely frustrating. It really is. And that is an issue really of practicality and not of policy. And I think the problem I've got about this bill is that actually we shouldn't have these powers dealing with policy. It goes back to what I said in the earlier debate. Statutory instruments were never meant to be about policy shifts, but about the practicalities or some adjustment. And, I think in a way these amendments, which may be right or may be wrong, but they're wrongly focused, because we should not be saying, oh, look, these very important things need lots of scrutiny because they're terribly important. Actually, if they're terribly important, they shouldn't be using the powers of a statutory. And therefore, I much prefer, you will not be surprised to know, the amendments in my name that we will get to later. The Amendment 4 and 5 that we've not taken because they were preempted, but we'll get to them, because this is basically also about the internal market. So we're talking about regulations that affect the other parts of the United Kingdom. There'll be very few or if any at all, that have no effect there. So what we will be proposing in our others is that regulation making will need the consent of the devolves, unless within a month that hasn't been possible, in which case then this Parliament will be, or government will be able to put them through, but with a reason about why they're doing it despite the devolves not having given their consent. So, I mean, that is an interesting one, and in a way it's a much shorter term than this. I think it's more focused, and it also specifically looks at this particular bill, which is about producing regulations that affect the other 4 nations. So I'm really sorry, but I prefer my amendment to these. But I think the issue of the scrutiny of statutory instruments is a serious one, and maybe we can hope that we get a better practice, so that we don't end up with stuff that at the end isn't quite fit for purpose, and then it's too late to do anything about.
Minister, Lord Truman.
My Lords, I'm grateful to those who've spoken in the debate, which I'll try to sum up briefly. Really, as the Noble Baroness opposite has indicated, because of the impact, and quite proper impact, of the preemption rule, and also the way the bill is grouped, and we're considering it, there will be further opportunities to address the points that Noble Baroness has raised in a later group, and indeed the points that my noble friend Baroness Neville-Rolfe has raised as to far as the appropriateness of the use of powers are concerned. I mean, obviously, my Lords, most amendments in this group do follow on and indeed precede, as the Noble Baroness opposite has said, discussions on powers. Powers which are all exercised in the bill as drafted by the affirmative resolution procedure. Now, we have contended that those powers, and do contend, are necessary to provide the flexibility to respond to future developments in the provision of goods and services trade. And as my noble friend Lord Callanan has said, and I venture to suggest might say again, we are fully committed to ensuring that these powers are used appropriately. In particular, this means the powers will be subject to parliamentary oversight in order to give them the widest legitimacy. And that does mean we will consult appropriately on the use of the power, including with each of the devolved administrations. Now, my Lords, as the Noble Baroness, my noble friend Baroness Mackintosh and Noble Lord Fuchs set out, most of the amendments in this group ask for a super-affirmative procedure, and indeed equivalent amendments were tabled, as the noble Baroness said, at committee stage. I would remind the House, as I did say also, without repeating all committee stage arguments, that Your Lordship's Delegated Powers Committee, which did consider these issues very carefully, did not propose any superaffirmative power in the bill. And I did explain problems with the proposed approach, which are very graphically described by my noble friend Lord Naseby, with his great experience in the other place, that this would cause unnecessary delay where a change is urgently needed. I made it clear that it's our view that the affirmative power is sufficient to ensure adequate scrutiny while enabling the government to act in the interests of the whole United Kingdom. And the core arguments haven't changed. As we've heard and seen, and today my noble friend Lord Callanan has tabled amendments to introduce consultation with devolved administrations and a requirement for the Secretary of State to review and report within 5 years on the use of the powers. Furthermore, the government has supported Amendment 2 to remove the power in Clause 3. I believe that taken together, these amendments deliver the additional assurances for consultation, due consideration, transparency and scrutiny that the noble lady seeks. But I do believe that the underlying objections to the superaffirmative procedure remain. And indeed, they're tacitly acknowledged, my lords, in Amendment 74, which curiously seems to allow the Secretary of State to set aside this procedure whenever he wishes to do so by declaring it's urgent. So that to me would be a very novel form of parliamentary procedure. It may be that the Law Society of Scotland has the answer to this one, but my lords, to legislate for a superaffirmative and then say that the Secretary of State can set it aside whenever he wants by saying it's urgent is a funny old way of proceeding, as it seems to a non-lawyer at the dispatch box. Therefore, my lords, I do urge the noble Baroness to withdraw her amendments. I ask her to consider that they are not proportionate, as my noble friend Lord Naseby has said. Turning to Amendment 9, this now refers to sections which I always defer to the wisdom of your lordships, and your lordships have just voted to remove sections 5 to 7 of Clause 6, including a reference to consultations. So the reference to consultations in this amendment, my lords, refers to sections no longer in the bill. This does, looking at the intent of the amendment, it does require publication of the results of consultation on the exercise of the powers that were in Clause 6. Well, my lords, devolved administrations and indeed the Secretary of State are perfectly free to publish their responses if they so choose, but I don't believe, the government does not believe, that that choice should be made for them in this bill. Therefore, even if the bill, the amendment still made sense in the new context, there is no need for the stipulation in it. And as it is, it no longer makes sense in context following your lordship's amendment to the bill a few minutes ago, and it doesn't seem to me to be a good way to make law, to send to the other place, if you like, a floating amendment which refers to consultations which are no longer within the clause. I hope that my noble friend will withdraw her amendment.
I've received no requests to speak after the Minister. Baroness McIntosh.
My lords, I'm grateful to all those who've spoken, in particular Lord Fowkes and Lord Beath, for indicating in principle their support to the super-affirmative procedure. And I note especially Lord Beath's comments that just because a procedure has never been used, there is no reason not to use it in this case for the purposes of primary legislation. I'm slightly disappointed that my noble friend, the Minister, Lord True, in responding to this debate, doesn't seem to get the strength of feeling, certainly north of the border, of the rather peremptory way, the peremptory fashion in which this bill was introduced, with only 1 month as opposed to the normal longer period for consultation to be had. And I do take issue with, and I hope this is something that we can discuss not just in connection with this bill, but in other bills as well. My clear understanding was it was always the government who used to publish in full the responses to its consultation procedures. And that was, I used to find that enormously helpful as a shadow minister in the other place, to go through and dissect comments that had been made and used to table amendments on the basis of those. So I can see there's a reason why my noble friend perhaps would not wish to publish the full responses. Also, I was disappointed that my noble friend said that the government will consult appropriately. I'm not entirely sure that from this little debate and from the background and the pace at which this bill was introduced, and perhaps the shortened consultation period that one might have had, that has necessarily been achieved. I note his comments that there will be other opportunities at this and later stages to consider how best to achieve the aims of these amendments. And with those remarks, I beg leave to withdraw at this stage.
Is it your Lordship's pleasure that this amendment be withdrawn? Amendment by leave withdrawn. We now come to the group beginning with Amendment 10. I remind noble lords that members other than the mover and the minister may only speak once, and that short questions of elucidation are discouraged. Anyone wishing to press this or anything else in the group to a division should make that clear in the debate. Clause 8, Amendment 10. Lord Stevenson of Balmacara.
My Lords, I am moving Amendment 10 and speaking to Amendments 20.
Clause 8, Amendment 10. Lord Stevenson of Balmacara.
My Lords, I am moving Amendment 10 and speaking to Amendments 20 market access principles. And I'd like to thank Lord Anderson, Lord Young, Baroness Bowles, Lord Wigley and Baroness Jones for the support, and to say how much I look forward to their contributions. My Lords, now that we have accepted by a significant majority Lord Hope's Amendment number 1, and the government has also said that it will not oppose Amendments 38 and 51, I hope we can assume that the common frameworks process will be at the centre of our future concerns about the internal market, and it will ensure, we think, that the devolved nations will be able, within the limits of the UK law, to formulate and apply policies that best suit their local circumstances, working together in order to enable the functioning of the UK internal market. So each devolved administration will retain the ability to diverge from the harmonised rules in their territory within the mandate given to them by the devolution settlement, but only after consulting the relevant policy group to see if a common outcome can be reached and agreed to. But we fully accept that there have to be backstop powers retained by the UK Parliament and subject only to the normal consult and seek consent modality. So we accept that this brings into play the market access principle system, which is set out in the bill. But, my Lords, that does not operate by agreement. It's hard-edged. It's a set of strict statutory rules which do not permit any real diversions. Indeed, for example, my noble friend Lord Farks mentioned in the last group, Clause 8 limits on the non-discrimination principle. The Clause 8 refers to legitimate aims and limits them to the protection of life or health of humans, animals or plants, and public safety and security. So it's very, very tight. But does it have to be that way? Surely we want exclusions which permit under various exceptions from the lists that are set out in our amendments 10 and 41, and others which will make the case for the extension of the legitimate aims in amendments 21 and the rest affecting services. The Welsh Government has put round a note which they prepared in response to the papers put round last night by the government, which argue that the bill's limitations have been too tightly drawn and that they go much beyond current international regulation, effectively putting new restrictions on devolved competence. I quote just from one of the policy statements issued yesterday by the government. Each part of the UK will be obliged to follow a rigorous process to justify an exclusion. This will include suitable evidence and a risk assessment shared between UK administrations to confirm the nature of the threat posed and the effectiveness and proportionality of any proposed measure in response. This is hard edge. This is not the language of consult and seek consent, let alone of a government trusting in the common framework process. My Lords, our amendment seeks to add significant exclusions to the market access principles for goods, for services, in relation to the recognition of professional qualifications. We think that they are justified, we think they're proportionate, and otherwise will not have an adverse impact on the powers which we think that the UK government must retain. I beg to move.
Amendment proposed. Page 6, line 47, at end, insert the words as printed on the marshalled list. I call the next speaker, Lord Anderson of Ipswich.
My Lords, it is a pleasure to follow the noble Lord Stevenson, and to have put my name to 5 of the 6 amendments in this group. The purpose of these amendments is to preserve the potential for legitimate policy divergence that is inherent in the devolution settlement. That potential is squeezed out for the future, save in limited and inconsistent respects, by the non-discrimination and mutual recognition principles as they appear in the bill. The scheme of these amendments is to provide for derogations from the applicable market access principles to be available on a consistent basis across parts 1, 2, and 3 of the bill. Such derogations would be safety valves against the pressures that build up when central and local interests clash. Safety valves of the sort that the member states of the European Union were sensible enough to give themselves in their treaties, and that exist in devolved federal and confederal states all over the world. But their purpose is more than merely political. The exercise of devolved powers has in the past produced creative and positive results in fields ranging from the requirement of fire suppression systems to the sale of electric shock collars. Noble Lords drew attention in the committee to the potential for similar action in future, if not prevented by the bill, from measures against obesity to bans on the sale of peat. The amendments are not a recipe for pointless and obstructive barriers to trade, which I strongly agree are to be avoided, because the use of those exceptional powers would remain subject to strict statutory controls. If challenged, rationality and the absence of protectionist purpose would have to be demonstrated, much as when the Scottish Government was put through its paces on minimum alcohol pricing. Yes, there will be cases in which compliance has to be demonstrated in the courts. Who, if not the courts, can be the arbiter of whether public authorities, whether central or devolved, have exceeded the limits of their legal authority? Litigation is always an inconvenience. I would not wish it on my best friend. But the universal fact that the scope of a legal power must, in the last resort, be determined by the courts is no sort of justification, I would suggest, for withholding or removing that power from the devolved administrations. As to cases that last for 10 years, as a barrister, I can only dream enviously of such a durable source of income. Urgent cases can be quickly resolved, and the major source of delay will be removed once we move outside the jurisdiction of the Court of Justice of the European Union, without whose intervention the time occupied by the Scottish case on minimum alcohol pricing, which delayed the introduction of that measure, would have been very much shorter. The common frameworks incentivize consensus. Among their many advantages, therefore, is a likely reduction in recourse to litigation. So I welcome Amendment 1, which, if it remains in the bill, will prioritise the common frameworks and significantly narrow the circumstances in which the market access principles apply. But for as long as those principles remain in the bill, it does seem to me that something in the nature of these amendments is needed, if only, as Lord Stevenson said, as a backstop. These amendments would diminish, in a controlled fashion, the crudely centralising force of the market access principles, and they would help to preserve the mutual respect between nations, which the perpetuation of our union requires.
Lord Young of Cookham.
My Lords, it's a pleasure to follow the compelling speech of the noble Lord Anderson. and I've added my name to Amendment 10 in the name of the noble Lord Stevenson of Balmacara, Lord Anderson of Ipswich, and the noble Baroness Lady Bowles of Berkhamsted. As I said during the committee stage of the bill, it is essential that all of the nations within the UK can pursue effective public health policies, which is my particular interest. Last Friday, my Lords, the Public Services Select Committee, of which I'm a member, published its first report on the lessons from coronavirus for public services. One of the key recommendations to the government was that there is an urgent need to recognise the vital role of public health in reducing deep and ongoing inequalities exacerbated by COVID-19. Unamended, the bill makes that task more difficult. While the committee welcomed the government's commitment to extend healthy life expectancy by 5 years by 2035 and to narrow the gap between the richest and the poorest, we also recognised that this would be tough to deliver. We called on the government to wait no longer before publishing its strategy to achieve this manifesto commitment and its response to the Green Paper, Advancing Our Health Prevention in the 2020s, a response which was due in January this year. My Lords, why is this relevant to these amendments? Currently, the internal market within the UK has the flexibility through exclusions to allow different parts of the UK to move at different speeds on public health. England was able to lead the way on restricting tobacco displays in shops, and Scotland and Wales are currently ahead on policies such as minimum unit pricing for alcohol. However, the Internal Market Bill may limit future innovations as the exclusions are both narrow and narrowly applied to only part of the market access principles. While policies similar to those I just mentioned might be allowable, it isn't difficult to identify future public health policies that would not. For example, in the explanatory notes of the bill, the government described how these rules would allow a packet of crisps produced or imported into any part of the UK to be sold in any other. But this leaves little space for governments within the UK to pursue future legislation that aims, for example, to restrict the salt content, size, or even improve the labelling of crisp packets. My Lords, the justification for this is unclear, as articulated in a blog from the Institute for Government. My view is that leaving the EU should not remove the ability we currently have for different parts of the country to move at different paces. This has meant that we haven't had to move at the pace of the slowest, and the different parts of the UK can benefit from the experience of the market leader, a point well made by Lord Anderson. The government has failed to explain why its list of exceptions is so much more restrictive than that of the EU, or indeed the WTO. While the justifications are unclear, the risks are anything but. Unless the bill is amended, some of this ability to innovate would be lost. This would be a step back for the UK, not a maintaining of the status quo. And the background over the last few years has been to give Holyrood and Cardiff more autonomy, not less. So the bill conflicts with that trend, helping to increase demands for independence and undermining the devolution settlement. And my Lords, it would not just limit the ability of the devolved nations to act, but that of England too. As part of its obesity strategy, the Department of Health and Social Care is going to consult on requiring calories to be included on alcohol product labels. The mutual recognition principle could hamper this legislation if alcohol produced in the rest of the UK is not required to display calories. Further, if overseas companies wish to avoid displaying calories, they could simply ensure their imports arrive in another part of the UK before moving them to England for sale. My Lords, when I and others in this House raised our concerns about this in committee, my noble friend Lord Callanan, responding for the government, was unyielding. Indeed, he said the exclusions from market access principles, I quote, were intentionally narrowly drafted to ensure that there are no unnecessary trade barriers that would ultimately increase costs to businesses and consumers while reducing choice. My Lords, the government has demonstrated that it is willing to listen to the concerns of the House. For example, the removal of the Secretary of State's powers to change the scope of the mutual recognition principle. Yet in other parts of the bill, the government has suggested a relatively small adjustment with a need to consult with but not gain consent from, the devolved nations before using these powers. There has still been no movement on the limited nature of the public interest exceptions in the bill, nor am I aware of any discussions on this which I called for in committee, and that's why the amendments have been brought forward again at report. My Lords, these amendments are supported by a wide range of health organisations, the British Heart Foundation, the British Lung Foundation, Asthma UK, Cancer Research UK, the Faculty of Public Health, the Mental Health Foundation, the Royal Society for Public Health, Action on Smoking and Health, and the Alcohol Health Alliance, for whose briefing I am most grateful. I very much hope that even at this late stage, the bill might be amended and the government might reflect the concerns that have been so widely shared on this subject.
I call the next speaker, Baroness Bowles of Berkhamsted.
My Lords, I support the general thrust of all the amendments in this group, and I have my name on amendments 10 and 21, which relate to goods. And I should also actually have put my name on the services amendments as well, because both I and my group support those as well. As was debated during the committee stage, we have already worked under a more generalised public policy legitimate aim regime while in the EU. And as Lord Anderson says, that provides safety valves which have now been taken away. At committee, the Minister argued that the UK internal market was different, and for some reason that meant it needed to be narrower. I cannot understand why, because perhaps we are closer together, that means that we have to have fewer freedoms because we have left the EU. So I agree entirely with the drafters of the amendment that there are many more legitimate aims that need to be spelled out. Realistically, differences are not going to be introduced into the market without a lot of thought. And as my noble friend Baroness Humphreys said during committee stage, Wales is a good size to experiment. And Lord Young has already given examples of various nations progressing at different speeds. Differences will only survive when they are practical and matters of good public policy or deal with specific problems within a particular area. But they should be allowed to be put to a proper test and not undermined from the start by immediate get-arounds. My Lords, these are important amendments, and therefore I hope that the government will consider carefully as to why it's necessary for this bill to undermine the freedoms currently enjoyed, because that is not how Brexit was advertised, whether you were for it or against it.
The next speaker, Lord Whitty.
My Lords, I added my name to the Amendment 11 in the name of the noble Baroness Boycott. She is down to speak later. She has indicated to me that she may not, because of other appointments, be able to make it, and she's therefore asked me to say a few words myself, more than I might otherwise have done. My Lords, I recognise that my noble friend Lord Stevenson's amendment lists a number of public interests exceptions which should be put into this bill, and there are good arguments for many or all of them. But surely, my Lords, in this crisis period for our climate and for our natural environment, the protection of the environment must be seen as an exception, and one where, for example, the Welsh government could take a lead, which meant different regulations on, for example, air quality limits, pollution in rivers, noise, dangerous chemicals, which was tighter than that taken by the UK or the English government. Now, my Lords, there are many examples where yes, Lord Anderson and the noble Lord Young have both said where the devolved administrations have indeed taken that lead. And if the government are opposing long lists, they ought at least to accept a short list of environment protection, because the government, my lords, are speaking with forked tongues on this. We've had this today, a 10-point plan for the long-term strategic approach to a green economy. We've had the Green Industrial Recovery Plan. We've had commitments to houses being fueled entirely by offshore wind. And we've had big commitments to green spaces and other environmental objectives. And of course, the government are trying to impress the world, rightly, now on our commitment when we take over to lead COP26 in Glasgow next year. But my lords, we also know that historically, trade has been regarded as being, free trade has been regarded as being breached when environmental protection regulations have been opposed in WTO and in free trade agreements around the world. There is a change, globally on the attitude towards this, and indeed to some of the WTO rules. But it would be absolutely absurd if, to preserve an internal market within the United Kingdom, we prevented progress by the devolved administrations or by England alone on environmental protection in the name of having a completely and absolute internal market and access rather than mutual recognition of different requirements. My lords, if a regulation or a tax process or a planning approach which preserved environmental protection aims is to be regarded as a barrier in trade in our internal market, then we are going against the trend of the whole of the rest of government policy and actually going against what is a rather slow but nevertheless clear intent of how world trade is going to have to be conducted in the age of the Paris Climate Agreement and the need to reduce carbon and greenhouse gas emissions. My lords, if there is one public interest limitation, then surely it ought to be environment protection. And that is what is provided by Baroness Boycott's amendment, signed by myself and Lord Randall in this group.
The next speaker, Lord Randall of Uxbridge.
My Lords, it's a great pleasure to follow the noble Lord Whitty. I too would like to speak and support Amendment 11 in the name of the noble lady Baroness Boycott. I was pleased to add my name to it. We've just heard, as I said, from the noble Lord Whitty, who also signed the amendment, and I think he's very astutely and eloquently put the case for this amendment. I apologise that I was not able to join your Lordship's deliberations at committee stage, but reading Hansard, I see that my noble friend the Minister stated that the current list of legitimate aims will in many cases align with the protection of the environment, and that expanding the list beyond the current list would increase the grounds on which goods from one part of the UK could face discrimination in another, and that would start to erode the benefits of the internal market and would make discrimination easier to create and implement within the internal market. With respect, I disagree with that. Amendment 11 adds the protection of environmental standards to the shortlist of what constitutes a legitimate aim. I think it's imperative that this time, where most acknowledge that we are in a climate and nature crisis, the protection of environmental standards should be considered as a legitimate aim. Indeed, as the noble Lord Whitty said, probably the most important legitimate aim. And we can do so without it being treated as indirect discrimination. And as we've heard also today, the government has unveiled a series of measures which are groundbreaking and very ambitious. And I don't doubt the government takes environmental standards very seriously. And I hope that this amendment will give the government an opportunity to give more power to its elbow. This, I believe, is a very achievable ask. I hope my noble friend the Minister will agree it will help to ensure that the internal market supports the achievement of environment and climate goals and targets at this crucial time. Thank you.
I call the next speaker Baroness Boycott, although I'm not completely convinced she's with us. Baroness Boycott? No. I will move on to the next speaker, Lord Wigley.
My Lords, I'm delighted to follow the noble Lord Randall and agree with much of what he said. I rise in particular to support amendments in this group, including the lead amendment, Amendment 10, and address in particular Amendment 21, which also stands in the name of Lord Stevenson, to which I have my name. And I very much agree with the comments Lord Stevenson made earlier, and I won't repeat his references to the pleas made to us by the Welsh Government on specific issues. To my mind, we quite clearly have to build in flexibility into this bill to deal with the issues which have already been addressed. In addition to the exclusions identified in Amendment 10, I would particularly refer to the two groups identified in Amendment 21, namely subsections F and G, those dealing with cultural issues and regional, socio-regional considerations. Although there are many aspects of these sections which merit our consideration, the category which I would like to highlight relates to the use of the Welsh language in Wales. Welsh is a language used widely in day-to-day life in Wales, a factor recognised by many commercial concerns who use Welsh for the promotion of their goods or services and for advertising. It may well arise that contracts offered by either national government in Wales or local government will include requirements relating to the use of the Welsh language, either in the delivery of a service or indeed in terms of the definition of the physical goods themselves. The use of Welsh in Wales is underpinned by legislation, and it's not a question of equal validity, a principle which was incorporated in the Welsh Language Act of 1967, then replaced by in the 1993 Welsh Language Act in favour of stronger provision, which has been further strengthened by legislation in our National Assembly a decade ago. Amongst other considerations is the matter of providing information in Welsh in order to give Welsh speakers the right to receive information and, where appropriate, to respond to it in the language of their choice. Such requirements can arise in terms of service delivery, particularly personal services, and community participation, and in terms of cultural activities. Could I therefore ask the Minister to give me some assurance that this bill in no way overrules or diminishes the rights of the Welsh language, and that dimensions relating to the Welsh language can be seen under this Act as a valid reason for a derogation? My Lords, before I conclude, may I respond to the earlier comments made by my good friend Lord Cormac in an earlier debate on the bill before us? Yes, I too would very much prefer to be with you in the chamber. And if I was, I would have pointed out to the noble Lord that Baroness Bennett is most certainly not the only member of the House who regards the Union as unacceptable in its present form. As he well knows, while I accept that all good sense tells us that there must be a close working relationship between the nations of these islands, one which would probably include a customs union and quite possibly some form of Britannic confederation, the present relationships just don't work in so many ways. These can best be encapsulated by the phrase, "Power devolved is power retained," a feature which has raised its head on so many occasions in our deliberations on this bill. As is acknowledged for Northern Ireland, both Wales and Scotland should have a fundamental right to determine their own future, whether in the present Union, a confederal union, or indeed in the European Union. In the meantime, we should also do our best to get on with each other, cooperate on those matters in which we have common interests, and avoid the excesses demonstrated by the Prime Minister in his remarks about Scotland last week.
Baroness Jones of Molescombe. My Lords, I will be brief. These amendments are basically about protection of environment, consumers, public health. I think these are all legitimate aims. And the noble Lord Randall actually made the very good point that with the government's, I was going to say, U-turn, swerve towards green issues, then actually these amendments can be very helpful. And so I see no problem with the government picking them up and saying thank you. Because one of the problems at the moment with the bill as it stands is that the government is trying to create a legal system that's actually more restrictive and overbearing than the EU single market ever was. And these amendments actually reintroduce the exceptions that exist in EU law which allows government to pursue a sensible policy that will benefit people and planet. One of the delights of my experience here in your Lordship's house at the moment and over the past 18 months has been and planet. One of the delights of my experience here in your Lordship's house at the moment and over the past 18 months has been I support them thoroughly and I hope that the government sees them as helpful towards its green aims.
I have to say that I am uneasy about this group of amendments because I'm not sure that they achieve what many noble lords want. This bill is designed to provide a UK single market, like the EU's, and indeed that of the USA, to ensure a properly functioning market that creates prosperity and economic security for our four great nations coming together in a united kingdom under Her Majesty the Queen. We want trade to flourish and to support business, interchange and the free flow of information. This helps the devolved nations, as 60% of exports from Scotland and Wales and nearly 50% from Northern Ireland go elsewhere in the UK, and they all benefit greatly from a transfer of resources, mainly from London. We want trade to increase as we see more import substitution following exit from the European Union. Public policy can be decided within that internal market framework, with some variations. We've talked before, and I support local variations, such as minimum alcohol pricing in Scotland and plastic bag regulation in Wales, which indeed I helped to encourage. However, they must be limited or the single market is undermined. So adding consumers, environment, labour standards, public and animal health, cultural expression, regional characteristics and equality in various ways, as these various amendments do, even with an opt-out where the relevant aim is already achieved, as in the noble Lord Stevenson's amendment, changes the whole character of the legislation on non-discrimination and market access. I mean, I note, obviously, the contribution of my noble friend Lord Young of Cookham, but I don't see how different rules on smoking or minimum pricing, or indeed the use of the Welsh language, which I very much support, would be ruled out by this bill. And as to differential labelling, whether on crisp packets or indeed on anything else, having different labels, I know from experience, adds costs, introduces logistics issues, and of course that puts prices up to consumers. It seems to me that it's actually much better to introduce labelling for health reasons and climate change reform of significance on a United Kingdom basis in the way it used to be agreed in Brussels. So I fear that these no doubt well-meaning amendments would provide a plethora of excuses to impose protectionist and other barriers between our four nations. So a source of dispute, not collaboration and harmony across our land, and a field day for the legal profession. It would not help us to achieve the leaps forward we all want on environment, on standards, or on anything else that have been the subject of this amendment debate.
I call the next speaker Lord Teverson.
My Lords, I'd like to speak to Baroness Boycott's amendment 11, although I'm very much in favour of the noble Lord Stevenson's amendments as well. And of course, devolution has not been a disaster in Scotland, in Wales, or in Northern Ireland, or indeed in London. It's something that has strengthened the United Kingdom and has strengthened our economy and has strengthened our societies as well. And my great fear of the overwhelming application of the market access principle, with those very few exceptions in terms of life or health of humans, animals and pets, or public safety and security, are far too restrictive and will mean that important parts of devolution will erode and disappear over time. And as in Baroness Boycott's amendment number 11, I'm particularly concerned about the environment, which includes obviously climate change as well. I will be brief on this, but the point I want to particularly make is that we've had arguments, particularly during committee stage, that the most important thing was maintaining strong competition within the United Kingdom. And I agree with that, obviously, but like on all things in market economies, they need to be constrained in certain ways. And I believe that while we need market competition to remain strong, it's also equally important for a modern economy for innovation to be able to take place. And the competition in regulation, in terms of environment and some of these other areas, is equally important to stimulate innovations in the nations of the United Kingdom that then others can follow when they are successful. That's what I see as a key part of this process, and being able to keep at the same time those different ways in which the nations of the United Kingdom are able to interpret environmental and climate change needs. I'm absolutely delighted, though, that the Minister responding is Lord Callanan, who is, of course, the government's climate change minister. And I'm sure that he will be absolutely persuaded by these arguments that we need to have these environmental innovations to help our climate change changes as well. And as we move forward, as the Prime Minister wants us to, as is shown in his 10-point plan today, to make sure that we keep that progress and do it in the many ways that the nations of the United Kingdom wish to do.
Call the next speaker, Baroness McIntosh of Pickering.
My Lords, I'm most grateful to have this opportunity to follow the Noble Lord Teverson, who chairs our EU subcommittee on the environment so expertly and courteously. I would just like to take this opportunity in speaking to briefly supporting Amendments 10 and 11, over which I would marginally prefer Amendment 10, but presumably these are for debating purposes. Could I ask my noble friend, Lord Callanan, when he comes to respond to this debate, is our understanding of the bill as currently drafted correct, that it does appear to be very tightly and prescriptively drawn, as so expertly indicated by both the Noble Lord Stevenson and the Noble Lord Anderson in their remarks? Or is it the case that the protection of the environment or indeed the labelling provisions as moved by my noble friend, Lord Young of Cookham, that these would be permitted? Is my noble friend Baroness Neville Rolfe correct that, for example, the labelling provisions as set out by my noble friend, Lord Young of Cookham, would already be allowed? My understanding is that, for example, in member states like Denmark, they can already provide additional information for consumers, such as the calorie content of beers and other foods, that we have not actually gone that far as yet. Would that be permitted under the bill as currently drafted, or do we actually need these amendments as moved in this little group here? I think that would greatly enable me to assist how exactly the provisions in the bill as drafted are to be interpreted. Thank you.
My Lords, I'm sure that the supporters of these amendments are motivated only by the desire to enable the devolved administrations to do the right thing in terms of protecting the environment and all of the other fine things that are mentioned in these amendments, though I have to say to the Noble Lord Stevenson, I have absolutely no idea what cultural expression, as mentioned in Amendment number 21, has got to do with the internal market. My appeal is to Noble Lords to remember that the aim of this bill is to ensure that the UK's internal market operates on a frictionless basis and allows businesses to trade within the UK with a minimum of barriers, as indeed they do now. And this helps businesses in all parts of the UK to operate successfully and profitably, which supports the aim which I hope that we all share of an economy which is growing in a healthy way. But more importantly, it delivers for consumers because trade barriers tend to increase costs and reduce choice for consumers. I have to say, my Lords, this is not a question of whether a particular regulatory rule will itself increase costs. We can argue all day about whether, say, increasing environmental regulation will increase or reduce costs for consumers. That is not the point. The point is about having different environmental regulations in one part of the United Kingdom compared with other parts of the United Kingdom, and whether that will work in the interest of consumers or against them. And I think, my Lords, that the answer to that is clear. If such regulations have the effect of erecting further trade barriers, the consumer takes the hit. My Lords, the absence of trade barriers is also crucially important when the UK comes to negotiate new trade treaties. Our negotiating strength would be seriously undermined if the government were not able to be clear on how the UK's own market works internally and how access would work for trade counterparties. International trade is not a devolved competence, and nor should it be, if we want to stand on the world stage as a major player. And I hope all noble lords would align themselves with that aim now that we've left the EU. Schedule 1 contains some significant exclusions from the market access principles. I urge noble lords not to make exclusions from the internal market so great, as these amendments have the capacity to do, that they kill the internal market in its cradle.
My Lords, Lord Cormac has withdrawn from this debate, so I call Baroness Clark of Kilwinning.
Thank you, and I would like to speak in favour of the amendments, and in particular Amendment 10, and in favour of the principle that any changes to the devolution settlement should not be made without the consent of the devolved institutions themselves, and that the UK exiting the EU should not be the basis on which it's determined whether a matter is a reserved matter or not, and to argue that this is not the time and not the circumstances when we should be considering taking powers away from devolved institutions and overriding their wishes. The devolution settlement was not one where the devolved institutions were created equal to Westminster. There's been a number of occasions today when it's been suggested that there should be that equality. Many peers have spoken about the need for that relationship of equals. I believe that is the direction in which we need to be going. And I think this debate again today highlights that that is the kind of constitutional arrangement that is definitely the kind of constitutional arrangement that people in Scotland are asking for, irrespective of where they stand on the independence issue. The examples that have been given in this debate today of Wales being able to legislate on the use of single-use plastic, I think are good examples to show why this legislation is unhelpful. I think it has been confirmed by the government in documents that the plans by Wales to bring forward proposals to ban all 9 types of single-use plastics referred to in the EU directive would not be possible if this bill was to become legislation. And of course, this bill would affect the ability of the devolved institutions to regulate any goods because they would require goods manufactured in that particular country to comply in certain ways, would only be relevant for goods made in that country. So goods made in Scotland could be regulated by the Scottish Government and could be required to comply with regulations, but goods being brought in from other countries in the UK would not be required to do so. So I listened with great interest to what Baroness Noakes was saying, and I fully understand the principles that she was outlining. But what I would say is that horse has bolted, and that is not where we are in the 21st century in the United Kingdom, and that we have to recognise the very different political cultures that exist within the different nations that make up the UK. And it's in that context that I think we have to look at this legislation. And there's been a specific example that's been raised by the Trade Union Unison about public procurement regulations, and I would ask that the Minister could perhaps consider this issue and whether the rules round about public procurement, which have been devolved to Scotland since 1998, would be protected if this legislation were to be enacted. The Scottish Parliament have indeed introduced procurement legislation which is different from that which has been enacted south of the border for social, for employment and for other reasons. And that has happened when Labour and the Liberal Democrats were in government in Scotland, and indeed under the Scottish National Party also, and that is because of the different culture that exists in Scotland. And could the Minister outline whether those regulations would be impacted by this legislation? That's just one example of the many areas of legislation that huge amount of work has taken place on since devolution, which could be impacted by this legislation. I put it to the Minister, and I understand that he is simply representing the government here today. He will have his own views, but these proposals are cavalier and irresponsible. I really would ask the government to look at these amendments, to think again, because the issues aren't just about trade, they're about the way that we relate to each other in this country and the way the four nations relate to each other. And if we cannot get the support of the devolved institutions for this approach, then I would respectfully suggest that it's the wrong way to take forward this issue.
I call the next speaker, Baroness Northover.
My Lords, I'm speaking in support of Amendment 10 and other amendments in this group. Powerful arguments have been made this afternoon about devolution, that common frameworks must continue to allow divergences in the devolved administrations and with England, and that the Internal Market Bill must not undermine this. The noble Lord Hope's amendment on this was passed overwhelmingly. At second reading, the noble and learned Lord Judge, who started in his regret motion by expressing shock at the government's plans to break international law, concluded at the end of that debate that maybe, stunned as he had been by proposals to break international law, he had overlooked the extent to which the bill also undermined devolution. In this group, we are flagging some of the areas in which devolved administrations currently have flexibility, yet this bill could prevent that happening, as my noble friend Baroness Bowles and others have pointed out. As the noble Lord Anderson pointed out, these differences exist in the EU, even with its powerful single market. I am not sure how deliberate the removal of the flexibilities that already exist has been, or whether this simply reflects the fact that devolution is not in the government's DNA. I agree with what's been said on the environment, but here I want briefly to flag public health, as did the noble Lord Young of Cookham. In the middle of a pandemic, this bill potentially undermines our ability to move forward in this area. In the public's health, we see variations which may well have played a part in encouraging the devolved administrations to take more ambitious action. The rates of alcohol-related deaths are more than 60% higher in the most deprived areas compared with the least. The highest rates of smoking are consistently found amongst those who are the most disadvantaged. Scotland has the highest rate of alcohol-related deaths in the United Kingdom, and its government has introduced a range of policies to address this. The Welsh Government has said that it will do more to extend non-smoking areas, which is also welcome. These amendments seek to ensure that when indeed a devolved administration is moving ahead of another, it can do so, and hopefully pull the others after them. There are fundamental problems with this bill. and undermining devolution is clearly one.
My Lords, I respect the views of the Baroness who's just spoken, but I have to say there's little in what she said that I agree with. Looking at Amendments 21, 48 and 49, which are really quite different to the Amendments 10 and 11, I mean, they go, in my judgment, way beyond what is necessary for a successful free trade market. Really, they amount to micromanaging. And on the whole, Her Majesty's government, in any form or other, whether it be devolved or central, certainly are not terribly good at managing commercial activities. So I would suggest that those amendments are unacceptable. I think Amendment 11 is one that I warm to because the environment is absolutely crucial. And we know in that context we include climate change and all that's affecting every nation in the world. So that is a very serious area. Whether this particular amendment's the right one or not is for, I think, the government almost to decide. I care deeply about the environment. I'm privileged to live outside of London. I shall drive home tonight 50 miles to Bedfordshire. And it is a very nice environment there, essentially a horticultural one, which brings me to the point, to a degree, that horticulture's changing, not least because we're looking to achieve a fair degree of import substitution. And there are all sorts of new challenges arising from that in terms of we virtually gave up in the glasshouse world and lost out to Holland. I know there are all sorts of experimentation about growing vegetables just in water, etc., etc., and this isn't the time to go into that. But I do worry, though, that there are products at the margin where there's always somebody lobbying against them. I mean, smoking's been mentioned. I've never smoked, but I accept the current situation that people have the right to smoke if they wish to do so. There are clear frameworks in which they can follow that. Pesticides, they are important in the horticultural world because they affect yield. So again, that's a controversial area, I know. So I'm going to listen to my noble friend, particularly on Amendment 11, where I have a reasonably open mind, but I do know that the environment is absolutely crucial. But I don't want to see areas of our society and our market squeezed out because of some heavy lobbying from one particular group who don't like the particular industry that is involved.
Mr. Lord Callanan.
My Lords, Amendments 10, 11 and 41 would expand the list of legitimate aims used to justify where statutory requirements in one part of the UK can indirectly discriminate against goods or services from another part of the UK. So let me start by saying that the bill provides an updated, coherent market structure which will help to avoid future complexities and help to prevent costs being passed on to customers through an increase in prices or a decrease in choices. An expansive list of legitimate aims would increase the potential discrimination faced by businesses or service providers, eroding the benefits of the internal market and creating damaging costs and internal barriers to trade. The current list in the bill is targeted to allow nations to meet their respective goals whilst avoiding unnecessary damage to the internal market, a point that was well made by my noble friend Baroness Neville-Rolfe. For example, the bill already includes the protection of public, plant and animal health, and in some cases, of course, these will align with the protection of the environment. However, and I cannot stress this enough, the government has repeatedly committed to maintaining our world-leading standards across a number of different areas, whether that is in consumer protection, the environment, social and labour standards, or public, animal and plant health. The bill does not undermine the great strides that we have taken in these areas, and we will continue to be at the forefront of improving and protecting our high standards. Under this bill, the devolved administrations will retain the right to legislate in devolved policy areas. Legislative innovation remains a central feature and indeed a strength of our union. The Government is committed to ensuring that this power of innovation does not lead to any worry about a possible lowering of standards, by both working with the devolved administrations via the Common Frameworks Programme and by continuing to uphold our own commitment to the highest possible standards. And it's important to remember that the market access principles do not prevent UK Government or the devolved administrations from adopting divergent rules for goods or services. Let me deal directly with the point made by Lord Wigley about Welsh language provision. The Welsh Government will still be able to require goods made in or imported into Wales to be labelled in Welsh, provided they are non-discriminatory. And the provisions in the UKIM bill will mean that these goods can then be sold throughout the rest of the UK under the market access principles. Those principles will simply protect against the application of new rules if they give rise to harmful barriers to trade. Amendments 21, 48 and 49 seek to introduce broad new exclusions from these principles for goods and services and the automatic recognition principle for professional qualifications. The framing of the exclusion allows the market access principles to be set aside if it can be shown that a measure is a proportionate means to achieve a legitimate aim as set out in the proposed new clauses. But that list of legitimate aims is so long that it would effectively render the protections in parts 1, 2 and 3 virtually meaningless. It would give little protection to businesses, to service providers or to professionals who wish to operate across the whole of the UK with a minimal regulatory burden. A regulator or a legislator could justify a very wide range of discriminatory measures using the justifications of the new clauses. The Noble Lord has attempted to remedy this with subparagraph 1c of the new clause, which states that the exclusion can only be used if it is not a disguised restriction on trade. My Lords, the Government's view is that the combination of a greatly expanded list and this new ambiguous concept of a disguised restriction on trade creates a completely unreliable metric, which makes the operating conditions of the UK internal market ambiguous for both UK businesses and for professionals. This amendment would create a massive additional burden on the judicial system through those seeking legal clarity on this legislative ambiguity on a case-by-case basis as to whether a matter is proportionate to a legitimate aim and whether it is in fact a disguised restriction on trade. And I can confirm to my noble friend Baroness McIntosh that, as I have explained on previous occasions, the exclusions and the derogations that we have drafted from the market access principles across parts 1, 2 and 3 are narrow and tightly defined in order to protect the functioning of important policy areas. This protects the ability of the devolved administrations and the UK Government to preserve the proper functioning of important policy areas whilst avoiding any harmful or costly barriers to trade within the UK's internal market. The Government's view is that the internal market framework is best served by a set of clear principles which are not caveated by the more expansive legitimate aims and exclusions that these amendments introduce. Allowing such wide and undefined exclusions would inevitably lead to new barriers to trade for businesses and for professionals across the United Kingdom market. It should also be noted that our proposed regime does not require a central authority to confirm or rule on public policy matters applying to DAs, unlike, of course, the system within the EU. This means that the devolved administrations are free to set their own regulations in devolved areas for their own producers, as long as those regulations do not result in trade barriers with the rest of the UK. And I can say to Baroness Clark that public procurement is not within the scope of this bill in relation to either goods or to services, so she doesn't need to listen to Unison in future on this matter. And with regard to her question on banning single-use plastics, we are, of course, committed to being a global leader in environmental protection and to maintaining our high standards in this area. In fact, the UK's plastic microbead ban came into effect in January 2018, which was a landmark step before, indeed, the EU introduced similar legislation. and the bill will preserve Wales's ability to regulate in line with its current policy for domestic producers. However, given our shared commitment to high environmental standards, it is only right that goods being sold lawfully elsewhere in the UK are not denied access to the Welsh market. This bill aims to ensure frictionless trade, movement and investment between all nations of the UK, and these amendments, in our view, would compromise our ability to achieve that objective. And for the reasons that I have provided, I therefore cannot support these amendments, and I hope that the noble lords would feel able to withdraw them.
My Lords, I've received no requests to ask the Minister any short question, and so I call Lord Stevenson of Balmacara.
My Lords, I thank everybody who's spoken in this debate very much for their thoughtful and often powerful contributions. It's been a very wide-ranging debate, but also one which has been very interesting. It's raised new dimensions, I think, in terms of the debate that we've been having so far today, and we'll have in the succeeding days on this report stage. And it made me think about two things that I just wanted to share with the House in concluding. A lot of the problems this bill has, I think, arise from the accelerated timetable it's gone through. And my feeling I'm left with after this debate is that if there had been more time for debate and discussion prior to the publication of this bill, we wouldn't be facing the rather uncomfortable tension between the wish to maximise consumer benefit and to reduce barriers to trade, which was expressed by a number of speakers and which we, I think, fully support, but not at the expense of being unable to respond to local wishes in the various parts of the country on issues that matter to local people. We want there to be a competition for the raising of standards, but also for innovation and new ways of dealing with issues of public policy that may come. It's very interesting, my second point is that it's very interesting that the various derogations and exemptions that appear in the amendments that have been discussed in this group actually mimic the concerns that were expressed during the trade bill, and indeed will be coming back in the trade bill later on in the year, and were resolved in the agricultural bill by the government conceding that there needed to be a statement about the standards of environment, animal welfare and animal production standards in relation to the agricultural trade and agricultural products. And if you add public health and you add social and labour standards, then we're back with the lists that appear on the amendments we are today. I wonder why that is. I don't really have an answer for it. But I also think that it's something that might be worth more consideration. And I will look very carefully at Hansard and try and see if we can find a common thread that might be picked up in some of the later amendments, which might well be worth pushing for further debate and discussion if we can, and if not, perhaps a vote. Just in passing, I should say to Baroness Noakes, whose contributions have always been of interest, that I'm sorry that she was foxed by the term cultural expression. I think I'm right in saying that this actually is the term that's used when state aid in particular is used to support activities which otherwise would be not possible. Particular reference here might be made to horse race betting levy, which would otherwise be banned, to the support that this government, building on work originally brought in by the Labour government to support the film industry, but also to support animation, high-end drama, and various other aspects of cultural life. I think that's where it comes from. So in a sense, if it's valid for anybody in public bodies, in the public sector somewhere, or in any elected organisation to wish to see more work, more investment, more activity in perhaps the green economy, as the Prime Minister announced today, then it's just as appropriate to say that there could be support for the cultural expressions, the term used to talk about the cultural industries. But I think, my Lords, the general feeling is that this bill is too tightly constrained around the way in which the market access provisions will work. And so much so that there might actually be disbenefits to consumers unless people in different parts of the country can respond differently to the issues they feel strongly about. As I said, I'm going to read Hansard and reflect on the debate today, but I think while I feel that the common frameworks will be able to carry most of the load of the issues that have been raised today, they will not take us all the way, and it may be necessary to come back to this issue at some future stage. But in the interim, I beg leave to withdraw the amendment.
It's your Lordship's pleasure that this amendment be withdrawn. The amendment is by leave withdrawn. Amendment 11 not moved. Amendment 12, Baroness Andrews. I should inform the House that if Amendment 12 is agreed to, I cannot call Amendment 13. Does the noble Baroness wish to move Amendment 12 formally?
My Lords, I spoke to this in an earlier group. I beg to move formally.
The question is that Amendment 12 be agreed to. As many of that opinion will say content, to the contrary not content, the contents have it. My Lords, Amendment 13 has been preempted. Amendment 13 has been preempted.
My Lords, I beg to move that further consideration on report be now adjourned.
The question is that further consideration upon report be now adjourned. As many of that opinion will say content. Contrary not content, the contents have it.
My Lords, I beg to move that the House do now adjourn.
That the House do now adjourn.